I'm guessing you have not forgotten about that huge NSA surveillance program that collects the phone records of millions of Americans in bulk completely haphazardly. A federal appeals court has ruled that the program is not authorized. Now, I want to be very, very precise here with the language I use, because when this ruling came out late last week, a ton of the stuff that was written in response to it was a little bit disconnected from the reality of what was said. So the Patriot Act has been mentioned off and on as the sort of justification for the NSA surveillance that we've been talking about now for a long time on the program. But the Second U.S. Circuit of Appeals in Manhattan said that the Patriot Act did not actually authorize the NSA to collect Americans' calling records in bulk. Sounds like a huge definitive ruling, right? But wait a second, let's take it a couple steps at a time. Number one, what evidence do we have that the NSA ever cared whether what they were doing was authorized? That's question one, Lewis, and I think we know the answer to that.
Yeah, we are well aware of this.
The other thing is that the appeals court did not really make a substantive ruling on the legality or lawfulness of the NSA's bulk data collection scheme. They didn't talk about whether it's constitutional or not. They just said, based on the case that was appealed to us, this particular type of NSA surveillance was not authorized. It was not authorized. So yes, the appeals court is on the record as saying the program as carried out is not kosher. But for those who are saying, huge victory, the type of surveillance is inherently illegal, that just didn't happen, Lewis.
And you could make all sorts of constitutional arguments that it's illegal anyway. Lots of experts will agree with you. Lots of experts won't. I mean, we still have this system in place, and it's not going to go anywhere because our government has basically declared it legal.
And putting that aside for a second, we still have a situation where, fine, it's not authorized, or fine, it's not legal, but now what do? Will this put any pressure on Congress to decide, oh, this is something that we're not going to do anymore? The key thing to keep in mind is that we did not see a ruling that this is certainly not a ruling that it's unconstitutional. And even a ruling that that the techniques themselves are illegal is not what we saw. We saw that the techniques are not authorized. It's hard for me to actually ascertain what people truly think about this type of surveillance, because if it's soon after some kind of an attack like 9/11, as we saw, people's willingness to accept this type of surveillance goes way up. If it's not near an attack and it's connected with some kind of whistleblowing sort of opera type of stuff, people get much more angry and opposed to the surveillance. But when can we say now the country as a whole is at a sort of equilibrium state where they're not forgetting about the fact that attacks happen, and they're also not completely traumatized by the fact that an attack just happened? Here is sort of the real opinion about surveillance from the country. I don't know that we can even really get that.
I don't think we can. Similar things have just happened. There was an attack in Canada, and immediately following that attack, you have Patriot Act type legislation. In France, there's the Charlie Hebdo attack. Immediately after that, you have something similar. I think it's human nature. We want it, and then after it's there, we don't.